According to a parliamentary report, divorce in the UK before 1914 was rare and oftentimes considered a scandal. It was mainly accessible to the wealthy as it was expensive and legally restricted. Individuals had to provide proof of adultery or violence. In the first decade of the 20th century, there was approximately one divorce for every 450 marriages. Today, there is approximately one divorce for every 2 marriages. Today, the average length of marriages before divorce is approximately 12 years. And since the introduction of the no-fault divorce in 2022, there was an increase of about 20% of divorce filing in the first year. So what happened? Well, we will be asking Phil Willans what happened in the last 50 years in the legal landscape as well as in the society as a whole. My name is Danna. I'm a lawyer by trade, but for today, I'm just your case finder. Welcome back, Phil.
Thank you very much. Thank you. I'm glad you didn't expect me to go back beyond 50.
Was it 1914? You got worried. Yeah, you got worried, but I started spurting out statistics before 1914. Well, what happened, Phil? I mean...
I can only talk about from personal experience.
Yes, of course.
I was articled, that's to say, that's what they call the training contract and articles of clerkship.
Mm-hmm.
I was articled in a firm in London that had a very, very big litigation practice, including a big matrimonial practice. So in other words, we did an awful lot of matrimonial work.
And this was around...
This was before the Divorce Law Reform Act in 1969.
Correct, yeah.
Which was the act which supposedly, well, in fact it did in many ways, revolutionise matrimonial law. It's always struck me as odd, actually, because virtually every year ever since, people have talked about its time being for no-fault divorce, but the whole basis of the Act of 1969 was to achieve that end. It said that there was only one ground for divorce, which was irretrievable breakdown, and then you look to see if any of a number of guidelines, desertion, cruelty,
reasonable behaviour.
Yes, that's well, cruelty was what they used to call it before that act. They changed it to unreasonable behaviour. Previously, punching somebody in the eye was cruelty. Mm-hmm. Adultery, that was the other thing. So there are about 5 guidelines. But people don't seem to have noticed the fact that introduced no guilt divorce, but it did. Mm-hmm. And the change was very considerable. Before that, you could have and did have many more defended divorces, and you had an awful lot of work in the magistrates' court, because it was only in the magistrates' court that you would get a separation order. People will no doubt have come to see you and said they want a separation order. Well, you can't get such an order these days. Mm-hmm. But in the magistrates' court, you could get a separation order, and as a sort of a mirror of the way society was in those days, the sort of reason you would get a separation order is if the court was satisfied that your husband had been cruel, and in those days it was a black eye, and they were drinking a lot, or one of the grounds I seem to remember was that you infected your wife with a venereal disease.
Understood.
See, so it was a much sort of harsher climate.
What sort of evidence was expected at that time?
Direct. I mean, it was no good. You had to meet the standard test for in any civil claim, basically.
It's more likely than not, which is translated to 51% in percentage terms. You know, it's not criminal, which is without a iota of a doubt, but it's a balance of probabilities. But still, you have to provide something.
Very much so. And even if a case was not defended, you as the petitioner, if you had transgressed in some way, you would have to file with your petition. I can remember doing it. What was in a brown envelope, what was called a discretion statement.
What's a discretion statement?
You're asking the court's discretion to grant you a divorce, notwithstanding the fact that you yourself have misbehaved.
Right.
So it would say, I, Fred Bloggs, am the petitioner. I have not committed adultery during the course of the marriage, save as follows. 1, with a girl I met at a party in Ealing.
So,
that was then fine. So when your petition came in front of the judge, because they did come in front of a judge,
yes, of course, yes.
look at, he would have a quiet look. It's always invariably a he. You'd have a quiet look at the discretion statement and decide whether or not to exercise it in your favour.
Right. Okay.
I mean, in those days, you didn't get, if you got a decree nisi, I think it was 6 months before you could apply for the absolute.
6 months, and that's in comparison to today's date, it's 6 weeks in 2025, yes.
And if you misbehaved in that time in some sort of matrimonial way, then, you were in trouble. They could say, well, you're not having a decree absolute, you misbehaved. So it was much more of a contentious system than that which was introduced by the 1969 Act.
Right.
And you could get legal aid to defend a divorce.
At that time, before 1969.
At that time.
Regardless of...
Regardless. If there was an arguable case, you could get legal aid. And then that changed because when they introduced no fault divorce, they were saying, well, it's straightforward now, you don't need legal aid, so you can't have legal aid.
It's not really no fault divorce, was it?
What they did was they introduced something called the green form.
Yes.
Where you could advise your client how to do their own divorce.
Yes.
And still claim legal aid. But the grounds of the contentious grounds shifted from the divorce itself. Who did what to who, when.
Yes.
Did they do it?
Yes.
It shifted to, they carried on arguing just as they did before, but now the arguing was through the children and finance more.
Yeah, that's correct.
And so it continued.
Let's talk about pre-1969, very, very contentious. It feels like this, although the same balance of probabilities apply. In 1969, it is packaged or was packaged as no fault divorce, but you still have to mention there is still an element of blame. I think that's the difference between 1969 and the major reform in 2022, which is there's absolutely no mention of any supporting factors to confirm that your marriage is irretrievably broken down. All it is now in 2022 is tick the box, and that's it. But in 1969, it's still a major leap, though, Phil, wasn't it? From this ultra contentious landscape.
Yes, I suppose it was.
What changed? And what was pre-1969? Of course, it was the swinging 60s. But what changed? And how was that? How did society responded to that 1969 reform?
Well, I mean, these are only sort of my idle observations and comments. You've got to bear in mind that attitudes to a lot of things change. So you've got the hanging, it was the classic example. That was brought to an end early in the 1960s. There was no more national service, which was again...
Was it 1960s as well?
I think it was,
roughly.
From memory, I think it was the early 1960s. So that there was the retreat from empire, which was Europe-wide. It certainly wasn't just England, or Britain rather. It was everywhere, you name it. Belgium, Portugal, France, Spain. That was what I would term a general retreat from empire across the world. And social attitudes were changing as well. So, for example, women were working more.
Yeah.
Before the Divorce Law Reform Act, and certainly going back, women tended to be at home rather than working. So society's attitudes were changing, and I imagine that that's why there were changes to reflect that in the law. That's all I can assume. I remember saying to my principal at the time, well, gosh, we've got a huge matrimonial practice. What on earth is going to happen?
Right.
And apart from a few sardonic comments, he was right. Basically, divorce work mushroomed because it wasn't so much the divorce, it was the argument about finance or about the children.
Correct.
And I've no doubt that's probably reflected in the law now.
Absolutely, I'm with you on that. Similarly, as what you thought would happen in 1969, I thought that divorce would also be less busy, manic. I thought we'd have less work because it seems like there is this almost collaborative approach that they were trying to encourage. But actually, it just shifted the inertia which these cases have. People, it seems that they want to have an argument. And if they can't have that argument, this is again a pretty bold statement. Of course, it's just a personal opinion. If they can't have an argument, if they can't have a catharsis there, they're gonna have it elsewhere.
Yes, I mean, well, that certainly reflects my comments, and that's what I have observed. If people are going to disagree, well, they're going to disagree. If they don't disagree, they they almost hardly get a lawyer.
Yeah, that's true, and then they wouldn't be in our.
That's a handful of people, isn't it?
Yeah.
And then right at the other extreme, there are those people who will never agree.
Yes, regardless of the Reform Act.
Absolutely, regardless of what the law says, they never agree with anything. And then everybody else is a shade in between somewhere. And then, I mean, quite as an interesting side shoot, you've got the sort of the social attitude of your generation, really, and those born near to you in age. The idea of you don't need to be married.
Yes.
Well, I mean, the fact is that the law, you're only supported by the law if you are married.
Absolutely
And
right.
yet people have sat in front of me and looked stunned.
Yeah.
When they've said, well, do you mean I can't, for example, claim maintenance?
Or pension, isn't
And
it?
I've said, well, no, you can't.
Yes.
There is no such thing as a law of cohabitation.
Correct.
I mean, I think I made some sort of remark about this last time.
Correct. Yes.
That if you're talking about reforming things, there are some fundamental reforms which are never ever addressed. And yet social attitudes are such now, I believe, without knowing what the figures or evidence is, that a great many people lead a perfectly normal family life, are not married and never intend to get married. Well, if things go wrong,
Yes.
if there are children, there's a small measure of protection, but otherwise you're thrown back on basically the laws of property.
A property which was not really intended for a long-term entanglement between, between people of intimate relationship,
Absolutely,
isn't it?
yes. You've got absolutely nothing to do with a married state. So that it's extraordinary, really, how you get these sort of, not lacunas, that's an old-fashioned word.
It's still used. I think in my generation, it was still used when I was in university. A lacuna. I don't know with Fermi, our third generation. Oh, she's saying no. It's no longer in fashion. But yeah, that's interesting, isn't it? It was used in my generation, but not used anymore in the current generation.
No, absolutely. But basically,
it's a gap. Yeah, a gap. Yes.
In the way that things are organised, and everybody persuades themselves and us, I suppose,
Yes.
that everything is so advanced and edgy and forward thinking. And in point of fact, if you really examine it, I don't agree.
No, it's a good, because it's like you, Phil. The clients who'd still be surprised as to why they're not quite protected, albeit 25 years of financial entanglement. And the only difference between this all-encompassing claim under the Matrimonial Causes Act versus this very limited claim under, well, Tolata, really. Tolata's trust of land, a property, is because one party, one case decided these people decided that they're not going to get married, and for whatever reason.
Well, and everybody thinks that they're very forward thinking, and we won't have anything to do with that silly old nonsense about religion and marriage and the rest of it. Well, fair enough, but they assume that they are nonetheless protected by the law. They are not.
There's no common law wife here or common law husband there's no such thing. Yes, never been in the UK, never been. So we get I get a lot of inquiries from my own community, so my heritage, my Filipino heritage, and there's obviously a gap in terms of approaches from what people thought they have as a default in this particular jurisdiction. But I don't think it's only a cultural difference. I think people just generally thought they'd be protected because of the status of the relationship that they had partaken in the last 20 odd years or 30 odd years, but they're absolutely not. And Tolata was what, for 1977, if trust of land? Right. We're looking at our research, because trust of land and Trustees Act. So as a background, if you are not married in the UK and you are having an argument about finances or disentangling your finances, you will not be treated as married people. You're just going to be... It's property rights. It's just plain property rights. So if you said, I gave up my career to look after my spouse, I gave up my career to look after, although there's, as you said, some level of protection if there are children involved, but a lot less compared if you are married. And I think even now that is still a sort of urban legend still an urban legend in this landscape. Phil, I want to go back because I want to go back to the good old days. Our research, I want to hear your thoughts about this. Our research unraveled that the world wars created an impact on the trajectory of divorce. And you mentioned it actually, this economic empowerment of women, because when the men went to war, suddenly women were having to work in non-gender traditionalist industry, and they had to carry on being the participants of the economy. Do you think that was the one of the factors, or was there a big reflection after both world wars?
Oh, well, I think it must have been. Basically, I think it contributed to the way in which social attitudes changed. So that unquestionably would have had an influence, so that if during the war you became a bus conductress,
yes,
or you worked welding cans, as my mother did very poorly, they all sank apparently when they were tested, in a factory, then it would inevitably, if it occurred on such a scale as indeed it did, have an impact on the way people saw their positions. But I think there was another factor as well, really, which was I think probably more important actually, and that was the incredible rise in prosperity that came from the 60s on.
Right.
So that and the pill.
Oh, okay.
So that it meant that women, first of all, families could afford to buy things better if both were working.
Understood, yes.
And there were so many things, from spin dryers to washing machines to televisions to you name it, that people wanted to acquire, motor cars and so on. So that if both could work and did work, then there was much easier access to that. And then when the pill came in,
yes,
women didn't have to have children. So they didn't have to stay at home looking after the kids.
Understood.
Well, it's probably an argument. Other sociologists might disagree with it, but it's probably why the German population has died the death. I mean, if you think how fecund the German race has been over the centuries, how many places on the planet it's peopled, not now, their population is declining. Why? Answer the pill.
Yes.
And I think probably with that, commensurately, a desire to realise their own it surely wouldn't be only, but realise their own economic potentials. So that I think that probably more than the wars.
Those evolutions, prosperity, as external factors affecting the dynamics of these units, these traditional units in society, affecting behaviors and approaches to, well, as you said, if one of the issues, and we talked about the shift in the financial arguments, I suppose, or financial dispute in divorce. Obviously, if there is an escape pod, i.e. they can work, they have a career, or they have some sort of a career, and there is a landing space for individuals after divorce, then I suppose people would feel, okay, it's a viable option, rather than academically they can divorce, but if it's not viable pragmatically, I think, as you said, people will be less likely to divorce. If people are getting prosperous, they have less responsibilities, more opportunities, they feel hopeful about, their prospects after divorce, then surely that will have some level of impact.
Well, now, you can see it reflected, can't you, in the house husband.
Yeah, yes.
Women very often earn more than men.
Yeah, I've had...
And men are supposed to be, including what they term the working class, suffering in some way from not being the main breadwinner.
Yes, no, right.
I don't know the strength or otherwise of those arguments, but the situation has moved on completely. Women are perfectly able, and normally, in my experience, are financially independent. So that changes the dynamics completely, doesn't it?
Absolutely.
But where it doesn't, it's surprising. I've been in courts in front of judges where they've expressed views. When it's been a man who's applying for some financial support from his wife.
Maintenance, the spousal maintenance, yeah.
There's very little chance of getting it.
There's still that resistance, isn't it? Yeah, I think we'll get challenged with this. Yeah, by all means, let's have lawyers, tell us about their experience. But I'm with you on that one.
That's right. The law is supposed to work both ways. Well,
yeah,
in my view, it is not equal.
Yeah.
It really isn't. Women are still seen as somehow being in need of protection, whereas the men aren't.
Yeah. No, fair point.
So it's only an observation, but
yeah.
I'm sure that's the view of judges a lot younger than.
Yeah, a lot younger than.
so society changes obviously over the years, but it doesn't always change quickly.
No, that's
I think the reverse is probably
point.
True.
Yeah, it's quite a process that sometimes could be tediously slow, for many reasons, and that's not meant to be a criticism. It's just what it is. It's just an observation. I'm with you on that. I have had pleaded spousal maintenance on behalf of respondent husbands or applicant husbands in divorces. So more so these days compared to early years of my practice, because I've been in practice even before the recent change. I'll tell you what as well. COVID and remote working changed a lot of our views about how we work. And in some ways, I'll tell you where from observation, it's affected most of our matrimonial cases. Children arrangement. Because now, people could say, well, I could do remote working 3 days a week, and I could certainly have an equal share of childcare. So traditionally, men, because that was how it used to be, would go out to work, and women would stay at home. But more so since remote working has been almost a default option these days. We've had pleadings where, we'll be asked, so what's the pragmatic proposal? And we say, well, client's remote working, he's had a chat with his boss, he's happy to take the children to school and collect them from school, and we could, this party who it tends to be not a limiting factor anymore. Going out to work does not limit you from, well, hypothetically, it's not as limiting to making arrangements for childcare, but obviously, I think I have a less say on this matter because I'm not a parent. But we would like to hear more. I've certainly pleaded it. I've certainly pleaded, remote working, and therefore we have the flexibility to have more time with the kids.
Yes, that must be true. I mean, it's really. COVID may have exposed it, but it's really technology that makes it possible, isn't it?
Yeah, it's technology. And all those, like, as you said, evolutions throughout the last 50 years. You've got the prosperity, you've got the pill, you've got the COVID remote working. That's changed how the expectations in society, as well as, what's possible in terms of settlement. It's so interesting. I mean, I don't know if you've done a deal on what's this Bitcoin and all this? I've not. It's all quite a. Yeah.
But there's a downside to this, you see. I mean,
go on.
Well, you might get lumbered with bath time.
Yeah.
Whereas before, you might be too busy to get home at a particular time. Now, unfortunately.
Yes. Yeah, you'd be like, well, we have to split bath time now. You have to turn up now.
A bit of a double-edged sword.
Yeah, exactly. More responsibilities. Well, let's talk about, because we mentioned this. You mentioned that one of the solutions to curbing criminal behavior is the refocusing on building a robust family unit that could support a young person to become quite a useful and reasonably competent member of society. Yeah. Can you expound on that? Because we just touched upon it last time, and you mentioned just ideas, isn't it? Reforms. You've already mentioned the reform of the cohabitation, but I want to hear your thoughts in this context.
Well, I mean, you'd have to set out to support the institution. We call it marriage, but it doesn't have to be marriage, because I think I mentioned the thought that occurred to me that you could have a civil partnership, if you like, which encompassed all forms of social arrangement, whether it be what we now have as a civil partnership, whether it be same-sex, whether it be marriage through a church, through rituals, whatever it happens to be, a composite arrangement. Cohabitees would no longer have to fear because they would be enjoying a new form of a recognised form of legal relationship, and the law would apply to them all equally. Mm-hmm. So then you'd have created, as it were, the walls around the relationship.
Yes.
So then when children arrive,
yes,
the children are then automatically protected by the law, as they are now to a large degree, but they're automatically protected by the law, as are the parties. And so you're reinforcing the institution, which is, as far as I can see anyway, and I'm no sociologist, but as far as I can see, it's the only really sound way to bring up children who are secure and responsible when they become adults. So that's one thing. The changes, it doesn't seem to me, would be that dramatic. But there are all sorts of other things. I mean, they could do as interims. So at the moment, if people are concerned about the benefit burden, mm-hmm. part of that's going to be for what they generally term as unmarried mothers.
Yeah.
Well, if you create a benefit system where it actually pays parties more to live separate, as I believe has been commented in the past, mm-hmm. then is it surprising that they do so? So if you don't want that to happen, you need to address that particular point.
An incentive, a tax incentive, perhaps.
And so some bright spark comes up with an idea. I mean, the situation was that if a young woman came to see you with a child or children and the father had left her mm-hmm. and not paid maintenance, you could take her straight to the magistrate's court and you could get an order for maintenance very quickly, usually a couple of weeks.
Yes.
So then some bright spark decided that wouldn't do, so they'd invent an entire new government agency, the CSA, to do the job.
Yeah.
Well, the problem about that was how effective it was. I don't know. I doubt if it was very effective. So whereas before you could help somebody get an order for maintenance, which could be enforced through the magistrate's court, suddenly they couldn't go to the magistrate's court, they couldn't get an order, they had to just complain to the CSA.
Yes.
And it all became much more bureaucratized.
Yes.
And I suspect highly inefficient. Very often the attempts to achieve a particular end frequently seem to me to be ill-advised.
Yes.
That's just one example that comes to mind. I have to think of others and bore you to death.
I don't think they'll be bored. I think I've been, been listening to you for now 15 years. I've never been bored, Phil. And I don't think that's just me. I don't think that's just me. A lot of we talked about doing this since 2021, and it's already evolved in this format. So we are happy to listen to all those stories.
Well, and if you could still get an order through the magistrate's court, it's the same old business. How do you enforce it?
Yes.
You extend to the magistrates the statutory power to link the order to, for example, through the national insurance system, so that people can be traced immediately through the national insurance system. And it must be very, very difficult if you're working to avoid a court order that is enforced through the national insurance system.
Yes.
Rather than creating some huge edifice, rather like the Crown Prosecution Service, rather than creating this enormous bureaucracy, which is guaranteed not to do the job fully effectively.
Yes, it's always, I think we talked about this in the past, that this, enforcement proceedings, whether in child maintenance, civil, or generally on all orders, and this is a candid feedback. I think we wish that it could have a bit more teeth, really, without.
Oh, it's got none.
Yeah.
Absolutely none.
I was trying to be, but you're right. I mean, we are.
It's pathetic, frankly. It simply does not achieve the end in the same way that the county court system does not achieve the end that most people desire.
Yes.
In medieval times, they had these what they call pie powder courts, so people would go from the market if they had a complaint, I suppose, about some product, straight into the court and get a determination on the spot. Well, that's probably a huge oversimplification, but something which is effective. I mean, it seems to me that in lots of ways, the law limps a long way behind actuality.
Yeah.
It really does.
That's very, very. No, but it's 50.
Provincial solicitor.
50 years of legal practice, a judge in, last 24 years until retirement. That's
only in a very humble part-time way. I mean, what is the law for heaven's sake?
Yeah.
It's by and large, it's often. I mean, the last. Nobody who is sensible should ever contemplate ever going to court.
There's a gap in terms of expectation and in current lingo, reality. And we try very much but and people need it. There's a demand.
You've got a system to work your way through. You're a guide through the system.
Yeah.
But it's jolly expensive. And it's misleading to think. I mean, it's got nothing to do with justice. I mean, the word is a complete misnomer in the context of the law. Nothing whatever. It is a system which society has evolved to meet whatever its needs are. I think it falls far short of meeting those needs, frankly, in all sorts of ways.
And there's a lot to do in terms of, connecting those gaps, isn't it?
Well, if somebody is so minded.
I think Phil Willans is available for parliamentary discussions. Well, here's a question deriving from 50 years of legal practice. How do you think, firstly, we could support individuals undergoing divorce as well as children of divorces? That's the first limb of the question. There's a follow-up, but if you could answer that first.
I think that it's best done by having a more all-encompassing system of the kind I've just briefly mentioned off the top of my head. I mean, after all, we've got the civil partnerships now. You've got the marriage, the vast marital matrimonial law that exists, which has been developed over the years. I mean, bear in mind, it was 1888 when the Women's Law of Property Act was introduced.
Yes, correct.
So it's been developing and developing and developing. Nothing happens overnight. Well, now is time for it to develop into a system which reflects modern reality. And if that system was there, then I think that is more capable of assisting people in difficulties, whether they be children or adults. And the form of that system is a matter for experts. I would suggest for people who actually have to operate the system,
yes,
rather than some bright spark in Parliament who wants to create a crusade and a subsequent seat in the House of Lords one day when they're finally wheeled off. So that's the way you do it.
We want a system that's a bit more aligned to today's realities.
Absolutely,
yeah,
absolutely aligned to today's reality, and I'm sure, I don't have any doubt that can be achieved, and quite possibly without a huge amount of alteration. You know,
alteration and cost.
In law, you have this thing. Oh, it's an act to amend an earlier act, or it's going to replace the earlier act. Very seldom does it. It normally just adds another layer.
Yes.
It's the already impenetrable layer of law, which exists.
Yes, it is. It's like a refurbishment, isn't it, to update the current sort of framework so that it's a bit more in tune with what's the needs, technological, the human behavior, societal behavior at the moment, children, all the stakeholders in this ecosystem that we have. The Matrimonial Causes Act, last reformed in 1973, wasn't it, Phil? Yeah, I think.
I bow to your superior.
I'm looking at my research here to fact check Matrimonial Causes Act, 1973, I'm pretty certain. Here's another, there's a follow-up question to that. What's your pragmatic advice to family law practitioners? How do we survive practicing in this? It's 1973.
There's an abundance of law. First of all, nothing is ever changed, or if it is changed, it's not changed effectively. And as my principal said when they introduced the Divorce Law Reform Act in 1969, and time and experience have proved him to be right. He looked at me and he said, "Philip, for every solution there's a problem." So my advice to family law practitioners is don't worry. You're always going to have plenty of work. So don't worry about it.
Don't worry.
Just so long as
If they're worried about work. And how about, we're talking pragmatic, not technical advice, more pragmatic advice, to any viewer who's looking to divorce in this day and age. What's your pragmatic advice?
Go and see someone quietly before you do anything at all.
Yes.
And look as closely as you can at the financial realities. Who owns what?
Right.
Who owns what?
Yes.
And then what will my requirements be if I'm going to tread a single path with or without children? So look in the same way before you start any court proceedings. You should consider, what am I trying to get? What are my chances of achieving it? And forget all about who's right and wrong. Forget all about justice. Just scroll back to and concentrate on the actual realities. What are you trying to achieve? And that should then enable you to say, well, what's being presented to me is unlikely to achieve that, or whatever the case may be. So look at the fundamentals before you do anything.
Very wise, and I think that's the most elegant paraphrasing of Matrimonial Causes Act 1973 that I'd ever heard. Elegant as well as user-friendly, I think, because we can all go into this enumerating what the law says, but as what Phil said, that's the pragmatic to-do list. Take stock. As objectively as possible, without any apportionment of blame, I mean, Naturally, people will, but that's the advice. That's the pragmatic advice. And speak to someone, speak to a legal advisor as quietly and as swiftly as possible before you do anything rash, or before you do anything major, before you make a major decision in this setting. Is that correct, Phil?
I totally agree, and if I just could add, and it needs to be a pragmatic lawyer.
Yes.
Not one who's your lecturer on the law, who cares what the law says or is. What you're concerned about are the things which I have suggested are the fundamentals. And so you don't want to be encouraged to launch into a legal crusade, which might be jolly interesting. It's like reading a law report. You know, by the time you reach the end of it, I, not you, I haven't got a clue what they're talking about. Because if you give them something to chew over, they'll chew over it from now till doomsday. That's not what you want. You want the problem to be resolved, not, oh, this is a jolly interesting point, and off you go on a jolly over the horizon.
Yeah, a few thousand billable hours later, a few tens of thousands, a huge billable hour, yeah. And then tens of £1,000s later, and then you're going to start thinking whether you're one step nearer to a solution or 10 steps further from it. I think at the end of the day, what the client wants, and this is, again, hearing this from you and other mentors, they want their problems to be solved.
Yes, they want to be guided through it. I mean, there's very seldom in law is there ever a complete answer to a problem. The people that come to you have got all sorts of problems. The situation is broken for one reason or another. When they leave, they're not going to be happy. But your job is to do your best for them you can, to lead them through the difficulties and advise and guide as best you can. But there's not a silver bullet or a magic wand you can wave to achieve what, generally speaking, they want, which is everything to be all right.
Absolutely. Well, thank you, Mr. Willans. That was, as I've said, elegant, pragmatic, user-friendly, and everything that really what you want from your lawyer. But before we close, we want as well to hear about your books again, because we wish to. One's about law. One's about I'm gonna grab it up in the beak. That's that's it. That's about a lawyer and a trainee solicitor, wasn't it? And if you want to know more about, but it's fiction, right, Phil, or inspired by stories without breaking confidentiality.
That's right. It's fiction based upon experience and slightly twisted facts. Not all twisted by any means, and it's intended to be light-hearted. And it's about law really as it was before we entered the modern age. So if anybody's interested, well, it might be worth a read.
Wow, very good. And the first one, Shapeshifter, was it's a bit more of an adventure.
Well, okay, it's about that, the group of people we hear about but never actually see because they're never interviewed or identified. It's about the post-war working class who has rather slipped below the horizon in terms of the modern world. And it's about the adventures of one young man who leaves his background and who goes through various changes as circumstances around him alter.
Metamorphosis,
yes. He is a shapeshifter. His shape shifts depending on what it is that he's confronted with, and that may or may not be of interest to somebody, I don't know.
Brilliant. Thank you. And you can get a copy, purchase a copy. We'll put a link somewhere, or you can write to us, Lawher office, and we can organize that for you. We'll add further information somewhere with this video. But yes, that's it. Phil, thank you so much. As usual, always a pleasure, discussing this with you, and hopefully, not just lawyers, but anyone who cares to listen will be able to sponge in all this, not just historical, but pragmatic and honest conversations about things that, interest us, concern us, and things we thought, hopefully could be better. Yeah, I think you'll be happy, and Phil is happy to accept a parliamentary discussion invite. But and final disclaimer, if you are indeed in a similar situation, this is simply a general guidelines. Please obtain independent legal advice, because each case turn on its facts, and you can't just use this and do a DIY approach to your case. Is still very, very much advisable for you to speak to a pragmatic solicitor, as what Phil said. Anyways, this is all for today. My name is Danna. I'm a lawyer by trade, but for today, with Phil Willans here, I'm just your case finder. Thank you.